Good morning. Thank you for joining this live webinar. I know I've been missing for some time. Things were a bit hectic. I think the public holidays played a huge role where that is concerned. And tomorrow is another public holiday. Unfortunately, it's on a Saturday. It would have been nice if it could be on a Friday or on a Sunday and we'll have a longer holiday period. But nonetheless, welcome to our webinar. Today I shall focus on family law in general. Live Q&A, of course. The questions I have on screen are questions that people posted a few days ago when we played a repeat video dealing with relocation of minor children. I thought it is fair if I pose those specific questions again, or at least deal with it if I can. I know many people, they watch these videos later on and they pose questions the evening, a few hours later, after we've already completed the live Q&A. Unfortunately, I cannot always get to those questions. They pile up after a while. But nonetheless, if you are online today, you are welcome to pose any questions that you may have on any aspect of family law, being it child maintenance, you want to claim child maintenance, an application for a reduction, you feel you are paying too much, you would like to pay less, you would like to amend the maintenance order, or the other party is not complying with the maintenance order, non-compliance, what can you do? Or you have not complied with the maintenance order and you cannot comply with the maintenance order. The other party took you to the maintenance court, to the criminal court, laid a criminal complaint. What can you do? What would happen? And so on. Child custody issues. You are being refused contact to your minor child. You would like to have more contact. You would like to have equal contact, 50-50, 1 week, 1 week. Or the other party is being unreasonable and the other party says, no, you can have contact, however, contact must be supervised by a third party. Or you'd prefer the other party to have supervised contact based upon the facts. You wish you never had contact with a minor child for many months, many years. The child doesn't know the other party. The party has a history of abuse. Or the other party is dangerous. We do not know. Whatever the facts are, please feel free to pose it and I'll try my best to assist you. Below my screen, you'll see the Facebook Live screen. That's the Advocate Muhammad Abduroaf Facebook Live page. It's live now. You wouldn't be able to see much. Nonetheless, you need to pose whatever questions you have on the Advocate Muhammad Abduroaf Facebook page, not on the Our Lawyer or any other page or any other group. I will not be able to see it live, at least, and I would not be able to be of any assistance or much assistance to you. So if you have a question, please head over to the Advocate Muhammad Abduroaf Facebook page and I would be able to assist you. Dealing with the topic at hand, I would like to obviously get some things out of the way, dealing with these specific questions that people posed previously. And the first question is as follows. It seems to me there's two question ones. There should be only one question number. But nonetheless, good day, Advocate. My question is in relation to passports for a 5-year-old. Father pays maintenance. I have a maintenance order. He has not seen the child in 2 years. He required visitation 2 years ago, and I refused and suggested that he approach a family court to have a parenting plan put in place. He refused. 2 years on, no contact. I would like to travel and he is refusing to sign for the passport. I approached the children's court to have the parenting plan put in place and to make contact with him. I intend to take it to the High Court. I desperately need to have a passport for the child. Is this the correct course of action? So this is a common scenario that comes to my desk very regularly. People who are in a relationship and now they have a minor child together, they separated and they have problems regarding their parental rights and responsibilities. For example, me and you purchase a vehicle. The vehicle is on both our names. I don't know if it's possible for a car, but definitely for a house. Now we're having problems. Our relationship came to an end. We moved on. We had an argument initially, but the car is in both of our names. What happens then? How do we deal with the situation? When do you have the car? When do I have the car? And so on. What are our rights? You would like to take the car overseas to a different country, to Lesotho. Can you do it? What is a requirement, etc. So I'm just using an example regarding that. Where parties are parents of a child and they both have some type of authority or rights over a child. Now, in terms of the Children's Act, for a minor child to obtain a passport or to leave the Republic of South Africa, both parents have to consent to that. That is a legal requirement in terms of the Children's Act. And if the other party does not give consent, you need to approach the High Court, the court for that. And the court will have to decide what is in the minor child's best interest. And if the court is convinced that it will be in the minor child's best interest to obtain a passport and to leave the Republic of South Africa and to be returned, the court will obviously make an order, and the court will basically give you that consent. The High Court or any court dealing with children's matters are the upper guardians of all minor children within its jurisdiction. If you live in Cape Town, you fall under the Western Cape High Court. Long and the short of it, to the Pacific commenter, you would have to approach the High Court and get an order. Basically, you'll draft a notice of motion stipulating what you require. Basically, you'll say that the respondent, being the father's consent, is not required for the minor child's application for a passport with the Department of Home Affairs. That will be your first clause, basically. Your second clause would be that the father's consent would not be required for the minor child to leave the Republic of South Africa. So if you are at border control, wherever you go, they'll ask you, did the other party consent? You will say yes. No, you did not consent, but you do not need to require the consent because you have a court order stipulating that the consent is not required. Should you go to the Department of Home Affairs and apply for a passport for the minor child, they will ask you, where is the other parent? More than likely, the other parent's details are on the birth certificate. You will reply and stipulate, I have a court order stipulating that only my consent is required, and that is it. Nothing else will be discussed, and the authorities will deal with the matter as if both parents consented to the passport application or the minor child to leave the Republic of South Africa. When dealing with an application like this, obviously the court will have to be driven as to what is in the minor child's best interest. That's very important. And the court will not be driven or make a decision based upon what is in the party's best interest or what they want. The court will focus on what's best for the minor child. And if it is in the minor child's best interest to get a passport, in my view, in my professional view, I believe any minor child should have a passport. And it is also a constitutional right, where the Constitution says everyone is entitled to a passport. So that argument regarding the passport should be the easy one. The child is at a certain age. There's a potential that the child might go overseas in the near future. Both parents should consent. If one parent does not want to consent, the court will say, it's a child's right. I can see no reason why the child should not have a passport. I will dispense with the requirement of the other parent giving consent. So that should be quite simple and easy. I would imagine that the reason why the legislature placed such a requirement in the Children's Act, Section 18, would be because many people, they abscond, they abduct minor children, they apply for passports, and there we go. And how would the other parent know that the child has a passport if the parties are in acrimony? So maybe both parents must come together and they must start to resolve these type of matters. It is a passport, it is an important thing. So basically, get both parents involved. You would hate to know that a child has a passport, that your child has a passport, but you were not part of that process, or you do not know about it. Regarding the minor child leaving the Republic of South Africa, you have to convince the court that it will be in the child's best interest. If you are going overseas on a holiday, that's fair, that's fine. The child should be able to go with you. I cannot see any reason why, unless there are other issues that applies. For example, COVID-19. You now want to go into a country where the pandemic is bad, and that could be a factor to consider. Should the court dispense with the other parents' consent, despite him protesting or she protesting that it is not in the minor child's best interest to go to that specific country? It could be a dangerous country. The visit wouldn't usually be a problem. The court will have to deal with the matter properly, but generally, if a child has to leave the Republic of South Africa to go overseas on a holiday and come back a few weeks later, I doubt a court will look into the matter too deeply if the court knows the minor child will come back after 3-4 weeks, and contact to the other parent can resume as normal thereafter. It is a holiday. The minor child may want to visit family overseas, or the minor child might want to go overseas because he or she wants to attend a tournament, an event, visit someone overseas, but the child is coming back. That's the important aspect here, the important factor. If there are clauses in the order that the court makes, where the court stipulates the minor child may leave the Republic of South Africa on the 1st of May, let's say tomorrow, but the minor child must be returned to the Republic of South Africa on the 1st of June, for argument's sake. That might be stipulated in the order. And the mother will know that she must bring the child back, or the father will know that he or she must bring the child back, on that specific date. Nonetheless, that should be a bit easier to deal with than the other application dealing with a situation whereby you want to relocate to a different country. Now, relocation has a lot of facets to it, and a lot of consequences. Even if a parent only sees a minor child once a week, once a month, in terms of an agreement, in terms of a divorce order, in terms of something. But now a relocation takes place into a different country. That has far-reaching consequences to the other parent. The parent will be staying behind, because the question that will be posed, when will that parent see the child again? It's a serious thing, because let's say the child sees the other parent every day, every second day. They have a very good bond not based upon WhatsApp, Facebook, Zoom, FaceTime, and those tools that you can use to do a digital communication with other party. But actually they hug each other, they play with each other, they swim together, they play soccer together. Real life interaction, as opposed to what we are doing here. That will have to come to an end. Yes, that won't come to an end, that will continue, but the real life interaction will come to an end. The court will have to determine, do I make that decision? Do I allow the parent who has care and contact over primary care over the minor child to leave the Republic of South Africa, go overseas, live there, and the parent staying behind will no longer have that interaction with the child on a daily basis? Yes, it can be done via electronically, but that's not the same. That's something else. There will not be that going to the shops together, the malls, going to Kentucky, buying ice cream, going to the shop around the corner to buy a packet of chips. That will not happen ever again. All the interaction will be via screen. But then again, the parent that is leaving to the other country, let us say for the mother, for example, she's going overseas for work purposes, and obviously the minor child will have to go with her, because the father does not have the capacity and the capability of caring for the minor child. He might have his own family. He might not be available during the day to care for the minor child as well as the mother is. he may be working all the time. Whatever the factors are, I'm just using a scenario where it will not be in the best interest of the minor child to be cared for the father because he's incapable of. There are many fathers out there, millions of them that can care for kids, but the scenario applies to that. And you cannot make a parent capable of caring for a child if the parent cannot care for the child. It doesn't make logical sense. Yes, he can acquire, give it a few weeks, few months, and he can develop those skills. But as I said, the scenario applies to that. But the mother needs to go overseas. She needs to get a better job. She's still ugly in Cape Town, Johannesburg, wherever she resides. COVID-19, and there are opportunities for her to go overseas. Overseas, there are schools for the minor child, medical facilities, should the child fall ill, whatever, extramural activities. There may even be a family member on the other side, an aunt, an uncle, who moved overseas a few years ago. There might be nieces and nephews, or sorry, cousins. Now, the court will have to make a decision. What do I do? Do I look at the rights of the mother for her to pursue her life and to move on with her life and build a career for herself? Or do I look at the father, whereby he will be limited from not seeing the child, but the mother will stay where she is, in her position, and she can excel? The father will obviously have a right to live his life. If he decides tomorrow to go relocate overseas, he doesn't require the mother's consent because he's going alone. He can pursue his objectives in life. But the mother is limited now because she cannot go overseas without the child. The court will have to make a decision. The court will obviously have to see what is best in the minor child's best interest. And if the court comes to a determination that it will be in the minor child's best interest for the mother to go with the minor child, and for the other parent living in Cape Town, in South Africa, Gauteng, KwaZulu-Natal, wherever, to have contact via these alternative means, via Zoom, WhatsApp video, etc., then the court will make such an order. The court will have to focus on what is best for the minor child. Because the alternative of having the child remain behind by the dad, it will not be in the child's best interest, because the dad never looked after the child the way the mother looked after the child or cared for the minor child. When the court makes such an order, the court will obviously have to deal with various aspects. What type of contact will the father exercise to the minor child should the minor child go overseas? That's very important to note. So the court will stipulate if the minor child comes to South Africa for visits, the child will remain with the dad for 2 weeks or half the visit, depending upon the facts. Or the father has a right to go overseas, and when he goes overseas, he can have contact with the minor child for whatever reasonable period there is, and video contact, telephonic contact, and so on. So we'll have to keep that relationship going as best as we can. That's what the court will have to obviously look at and decide upon. Very complicated cases. If a client comes to my office with a case like that, I obviously put my best foot forward. I try to be as creative as possible. I can only present the information to the court. The client has a lot of homework to do, extremely a lot of homework to do. I want to see information where she communicated with the school. There's a school available for the minor child once a minor child lands in the new country. I want to know the area where the minor child will be residing. Are there hospitals? I would like to know whether or not the mother has been guaranteed employment, or is it dependent upon her getting the order, or dependent upon her landing. That's very important, because we do not want to have a situation where the mother and the minor child leave South Africa, they land in the country, and there is not accommodation or indefinite accommodation. There might be a 1-month accommodation. What happens then to the minor child? The minor child, for argument's sake, does not have a school to be enrolled into, or once she lands, then she will be applying for a school. Yes, it's possible that the court can consider that if she has a good reason why she's following that specific procedure, depending on what time of the year she'll be landing. If the minor child completes schooling year in South Africa and it's holiday the other side. So it depends on a lot of factors, but the client has a lot of homework to do. I need to convince the court that once the child lands overseas, the child will not be in any worse position. I'm referring specifically to caring issues. The child will not be in a worse position from a caring point of view should the minor child remain in South Africa. What the father who remains in South Africa needs to convince the court, and what he should try to convince the court, that it will be best for the minor child to remain in South Africa. That will be challenging for him. If he came to my office and I had to represent him, I also have to now be creative and have to listen to what he has to say. He might, for example, say, no, the child needs to remain in South Africa. He has certain schools he has to attend to. He can pursue academically better in South Africa. He's on top of his game. The country where they tend to go to, they speak a different language. Let's say the family is English speaking, and they'll be going to countries where the minor child or the mother understands the language, for example, Italy, and the majority of the country runs on that specific language. Or, for example, Cambodia, or China, those countries. Yes, there's an argument that English is spoken at certain schools, and that must obviously be argued by the mother. But the father is more concerned about those specific factors. And of course, the factor that he will not see the minor child. And he might say he believes that should the mother go overseas with a minor child, things will not be as well presented as a mother would want it to be, and there will be issues in the future. So those are the problems that the father must come with and unpack and outline and try to convince the court. He cannot just thumb suck. He needs to be prepared. It needs to be legitimate concerns and legitimate issues to which he has regarding the actual relocation. If they are legitimate, the court has to consider it in conjunction with what the mother presented to the Honorable Court. And the court will have to make a decision. The court may want to consult with experts, the Office of the Family Advocate, a childcare expert, to consult with the people, to consult with the family, to do some investigations, to follow up on the phone calls. That's very important. So if I represent the father or I represent the mother in our scenario, the party remaining behind or the party going ahead, our brief will be to focus what is best for the minor child. And the data which I receive from either party needs to be material, needs to be relevant. If the mother decides to go overseas to marry someone, she has a fiance and he lives in a different country. That's an important thing, because why must the mother now remain in South Africa for the sole reason to allow the father contact and her fiance lives overseas? So those are things which you have to look at. It's very important. If the father, now I'm putting on the father's advocate hat on, I'm no longer representing the mother. If the father believes, yes, the mother, she can go overseas, she can pursue her career, which she has a right to do, but at the same time, he is capable of caring for the minor child just as well as a mother is capable of caring for the minor child. The minor child is now 12 years old. He'll be attending high school soon, and so on. And the minor child has been living with him every second weekend for the last 2 years. He shares half the school holidays with the minor child. He attends to the child's homework. When the child is ill at night, he attends to the child. Many times the mother had to go away on holiday, on work, for work purposes. She had to go somewhere. And the father cared for the minor child for a month, 3 weeks, depending upon the facts. And he is capable of caring for the minor child. His argument will be, wonderful mom, you can do what you need to do and I'm happy for you. But I do not see why the minor child should go to a new country, to a different country, start all over again. If he can stay in South Africa, complete his schooling. Once he's 18 years old, he can decide where he wants to go to. He's an adult. But complete his schooling, he's enrolled in the sporting, whatever he does, and I can care for him because I am capable of caring for him. That's when my advocate hat for the father comes on, and I will pursue that and I'll argue that. The issue then becomes not whether or not the facilities in the United States, in Italy, in Germany, in the Ukraine, what other countries are there? Cambodia, China. The issue is not whether or not the country itself is dangerous, the country itself has issues. That's not the issue. The issue is whether or not it makes logical sense to remove the minor child from his home, the schooling he's in, and have the minor child reside with the mother in that specific country if the father himself can care for the minor child just as well? Will the child be in a better position to go overseas with the other parent, or will the child be in a better position to remain in South Africa? So that will be the argument. That is why when I consult with clients, it's very important that we deal with the nitty-gritty. We need to deal with the issues at hand. If you do not have a clear strategy on any legal matter, and this is now for people that are attending to their own legal matters, if you do not have a clear strategy as to why you are stipulating anything in your case, you will not be successful in your case. You might be, depending upon the court and the judge, but you will more than likely not be as successful as you would have been had you had a clear strategy. Many people, when they draft these type of applications, they just badmouth the other party. They deal with the separation, the affairs, all the bad stuff. I do not want to mention all here, but all the bad stuff. And they don't focus on what is important. In a relocation application, the court doesn't care about the parents. They will not be seeing each other in any event. Mom will be in Japan, dad will remain in Johannesburg. The question is, with who does the child remain? And in determining that, we need to determine what the factors are, what the facts are, what the issues are, and what issues we need to focus on and argue on. And you focus on that. Do not blur the issues. If you blur the issues, remember the magistrate, the judge, they're all human beings. Their brains are just as sharp as the next smart person. But human beings can only deal with so much data and so much capacity. You need to keep the judge, the magistrate, on your train track. Don't let him be sidetracked by any other issues. Your focus, if you are the father, I can care for the minor child. The minor child's interest will be upheld by remaining here, his stability. He does not now have to go to a different country, start all over again. The mother's case will be, no, I've always cared for the minor child. I can care for the minor child. The minor child needs to be my care because when he's sick, I can look after him. Overseas, there are better schools, better facilities, better lifestyle, and he needs to explore that specific aspect of his life. Why must he remain in South Africa? Same government, same issues, same policies, whatever the case may be, the good and the bad. Why can he not experience something new overseas? I think you follow where I'm going to. Sorry about that. And I hope I answered question 1. And now we're dealing with the second question 1. Good morning. I've been battling. I have to beg my ex to everything with our kids. Okay. The big one is when school documents need to be filled and signed, etc. Then also where the payments were where we're supposed to pay 50-50. Is there a way that I can get better custody? Okay, I see the problem. I copy and paste these questions verbatim. I do not change them. So the person is basically saying he's battling with everything regarding the minor child or the minor children or the ex. School documents need to be completed. Problems with that is concerned. For example, and I'll put my own example in here. The minor child needs to attend a certain primary school. The school requires both parents to consent. Makes sense. To sign the documentation, to provide all the stuff, their proof of address, their income, whatever, I do not know. I'm trying to be as difficult as possible. But the school requires the cooperation of both parents. The other parent does not provide that specific consent, that both of them agree that the minor child should go to the specific school, and this delays matters. It causes problems. The same way when it comes to fees. They're supposed to pay 50-50, but the other parent refuses to pay 50-50 or delays payment. There are 2 issues that I'm looking at here. The one issue is that of child maintenance. Obviously, if a party does not pay child maintenance, it's a criminal offense. But here we have an issue regarding the school. The school does not really care about the parental issues. The school is concerned about getting paid. They have bills to pay. They have to pay things. And you have an agreement with the school. Your child is in a school. You provide him with certain amenities. We have to pay certain people to come in, certain teachers, depending upon the school. And if you do not pay your fees, it prejudices us. Both parents have an agreement, or there might be a maintenance order in place that you should share school fees 50-50. The one parent is not, doing his job or her job. Then there's the other aspect. The aspect which I'm seeing here is guardianship issues. Dealing with issue concerning consent, signing of documentation. Those documents are signed by the guardian of the minor child. There's a difference between care and contact rights and guardianship rights. It's very important you need to understand this, especially if you are pursuing your own legal case. Care and contact rights, what does that mean? That means, when do you see the child? Do you care for the child? Does the child stay with you? Does the child wake up by your home? Do you take the child to school? Return the child? Phone the child? Etc. Care and contact, the care of the child. Custody, that's a term they used to use. The new term is care. Many people contact me, they say, I would like to have sole custody over the minor child, but they're all talking about consent issues. Wrong. You want to have sole guardianship rights. What is guardian? Guardianship rights refer to the legal aspects of a minor child. Nothing to do with contact. To put you in a picture, a parent can have no contact rights, no custody rights. He or she is not allowed to see the child ever by court order. But that parent can have 50% guardianship rights. You don't say 50%, it's co-holder. Both of you have that rights. But a parent can have full guardianship rights or co-guardianship rights with the other parent, although he or she is not allowed to see the child or be in the same proximity of the child, because you're dealing with the legal aspects. For example, what's legal? As we spoke earlier on, the passport application. Nothing to do with visitation. It's about giving your consent. May the minor child obtain a passport. Simple. The minor child wants to leave the Republic on a holiday with a mom. Consent. Guardianship. The minor child wants to go for an operation. The surgeon asks, where are the guardians? If something happens over here in this operation, I will be responsible and the guardians will come after me. The minor child wants to sue someone. Let us say the minor child has a car at the age of 17 years old, an expensive car, maybe not a motor vehicle, something expensive, and somebody smashes it, damages it. The minor child obviously wants to sue this party. Because he's a minor or she's a minor, he or she will require the assistance of the guardian. That's how it works. So we're dealing with legal aspects. If a minor child owns a home, maybe that's a better example. The minor child owns a property. The law specifically says for the minor child to alienate a property, to sell it or give it to someone else, both guardians must consent for that. Nothing to do with visitation. It's a third party. It's something different than visitation. It's legal. Care and contact, visitation is day-to-day activities of the minor child. So I think we dealt with that now in detail, the difference between guardianship and care and contact. So question number one, the second question number one here in front of me relates to guardianship. So my answer to you is, you need to apply to court and ask the court for an order stipulating that when it comes to matters concerning consent regarding schooling, only your consent is required, or only your guardianship consent is required in relation to those specific issues. Therefore, moving forward, should the court grant to such an order, whenever you approach the court and ask you, where's the co-guardian's consent? You say, no, here is the order, I'm the sole guardian over the minor child, only my consent is required. Obviously, other issues may arise. Is the school willing to only deal with you regarding school fees? I'm certain there are ways we can go around that. Maybe the court can make an order, the maintenance court, that he pays you the school fees and you pay the school fees to the school concerned. Therefore, the school does not have to deal with the other parent. The school only has to deal with you. But however, if the other parent does not reimburse you for his half share or her half share, clearly then you can approach a court, the criminal court, go to the maintenance court, lay a criminal complaint, or they can attach your salary and so on. That could resolve that specific aspect. The next question which I received, not necessarily a question, the person wants to know a lot of things, and I do not think I can deal with all of that. I'll require about a few webinars for that. Goes as follows. Please can you mention about section 15 of the Maintenance Act? A lot of people miss that. And 50-50, 1 week, 1 week, which forces one parent to pay while looking after the child and the other parent to pay while looking after the child. All this needs to be read with 50-50 maintenance as well as equal rights and responsibilities, which can be interpreted as 50-50, section 28 of the Children's Act, I presume, or the Constitution. Best interest principle, your views. Okay, that's that. And the same person asked the additional questions. Can elaborate on section 1920 of the Children's Act, section 15, Bill of Rights. A lot of data has been posed to me. Obviously, I cannot deal with all of that in one webinar. It needs to be dealt with properly. I need to bring up those specific sections in a PDF document on the screen and deal with it. So I will not deal with it, but I'm just doing justice to the person's specific question. The person goes further, dealing with SAPs, clinical psychologist, etc. Thank you for the question. Obviously I looked at it, and maybe in my future webinars going forward I can deal maybe with one of those aspects at a time. But maybe I can deal with this question regarding 50-50 maintenance. How does that work? Is it possible? Under what circumstances? And let's look at the time. Okay, we're doing good with time today. 40 minutes we're live. The general trend that wasn't applicable some time ago, a few years ago, is that people are now moving towards 50-50 contact and care. Now when I say trend, it's not a norm, it doesn't happen regularly, but it happens more than usual, whereby parents agree that the minor child resides with them for 1 week and with the other parent for 1 week. 50-50, which is good. I mean, wonderful. If the parties can agree to it, I am happy. My policy on child maintenance matters and child care matters is that if the parties can come to an agreement, I am extremely happy and I will enforce that for you. I do not live your life. I do not know the minor child. I only see you when I see you. I might not ever see you ever again. You are the parties that have to live with whatever agreement you have made. Therefore, if the agreement has been done mutually, both of you have agreed to it, you know your life, you know the intricacies of your life, you live together, you might not have lived together, you know your minor child better than anybody else would ever know your minor child. No clinical psychologist, no social worker will ever know your minor child better than you know your minor child, you and the other party. Therefore, even if you come to an agreement stipulating that the minor child will only have contact with the one parent once a month, and that's best, and you believe that's best for the minor child under the circumstances, who am I to judge you from my armchair? I do not do that. You believe that's best for the minor child? Let's implement it and make it happen. Therefore, I do not interfere with that. 50-50. The minor child resides with one parent, for example, from a Friday after school until the following week, where the other parent collects the minor child from after school, or from the Sunday evening 5 o'clock, where the one parent collects the minor child from the other parent and drops the minor child at 4:59 at the other parent's home. So you just work it out. So if you have the child, you drop the child, or if you do not have the child, you collect the child. Now, does that mean that maintenance should now be 50-50 as well? No, it does not mean that. Maintenance and care and contact are two separate issues. It is possible that a parent sees a minor child every second weekend. So you're the visiting parent. You're the mother. The father is primary care with the minor child. The child is with the father for 26 days in a 4-week cycle, evenings at least, on a 4-week cycle. You have the minor child with you on 2 evenings on a 4-week cycle, every second weekend. Friday till the Sunday, Friday night, Saturday night, Sunday night, Sunday morning, or Sunday afternoon, drop the child back to the other parent. So you are the visiting parent. I'm using a simple example here. Does it mean that you cannot claim maintenance, or shouldn't you be able to claim maintenance? No. we look at your income and your expenditure and the needs of the child. If the other parent, the primary caregiver of the minor child, is extremely wealthy, earns a lot of money, etc., and you are not so fortunate, but you are only entitled to have care and contact with the minor child for a period of 4 days per month. But in order for you to exercise contact with the minor child, the child needs to eat, the child needs clothing, or the primary caregiver might buy that, but the child needs food, the child needs accommodation, the child uses Wi-Fi, the child uses electricity, the child uses water, etc. There is a figure applicable to that. The child has expenditure, living expenditure. The child sleeps in a room, and you have to make this room available for your specific 4 days for the month contact. So, given that example and that scenario, you earn 1,000 Rand per month. I'm using round figures, simple figures here. You earn 1,000 Rand per month, but when you care for the child actually costs 2,000 Rand a month because he eats a lot, or she eats a lot, or they eat a lot. They use a lot of electricity. They require certain type of soaps. I'm using a silly example, but this is how to get my point across. Someone has to pay for that. You can't afford to do that. Therefore, under these circumstances, because the other parent is very wealthy and can afford it, you can claim maintenance from the other parent, the primary caregiver, to contribute towards the maintenance of the minor kids whilst they are in your care. I think you follow where I'm going to. I never dealt with a matter like that specifically. Obviously, 50-50, clearly. Same principle applies. You might have the minor child for half the time, but the child still eats, the child still requires certain amenities. I cannot afford to do that, but it is in child's best interest for me to have contact with the minor child. We find that those circumstances, the maintenance has to be looked at. And what's fair and reasonable under the circumstances, so either one parent earns much more money and I earn much less, the other parent will have to pay a contribution towards the maintenance of the minor child. And I think that's it for today. Sorry, we have one last question. Let me deal with that first. Morning, sir. My soon-to-be ex is threatening me that he'll take our 14-year-old from me or withholding payment as tools to bullying me. You see, the challenge I have here is many people like to bully. They like using words. I'll take the child away from you. I don't know how that works. How do you take a child away from you? Or you'll never get a cent from me. Or the maintenance I'm paying you now, the 5 Rand I'm paying you now, you'll never see a cent more than 5 Rand. If you go to the maintenance court, they'll make me only pay you 1 Rand or 20 cents. That's only words, it's only talk. If he's threatening to take your child away from you and it's in the child's best interest, I cannot comment further. The law applies what's best for the minor child. What is the reasons for that? If it's best for the minor child to be with him, that's it, and that should be the case. If you feel that he's being unreasonable, then obviously, under those circumstances, the matter will have to go to court, and the court will have to decide, or a mediator or facilitator, whatever the case may be. So do not necessarily just take a threat from the other party. If he does take the child away from you, immediately lay a complaint, go to court, go to the children's court, see an attorney, deal with the matter, and the court will ultimately decide what's best for the minor child. So you can say, I'm taking a child away from you. What you should say, I can prove to the court that it will be in the minor child's best interest for the child to be in my care. The court will make such an order. The second part of the question is the holding payment as a tool to bully me. Approach the maintenance court. Maintenance has nothing to do with care and contact. Therefore, if he's not paying you, approach a maintenance court. That's my advice to you. Okay, it's 1 minute to 11. I still have a lot of work to do. Thank you very much for your time. Thank you for partaking in this webinar. And I hope to see you online soon. Thank you very much. Bye-bye.